Go on the record, please. This is cause number 2021 CR 7042 and 7043, the state of Texas versus Francisco Rodriguez Contreras. Attorneys, please make your announcements for the record.
Travis Rodriguez for the state of Texas.
Good morning, Your Honor. Hugo Javier de los Santos for the defendant, Francisco Rodriguez.
Mr. Rodriguez is appearing by video conference from the Bexar County Jail. Go ahead and tell me your full name, sir.
Francisco Javier Rodriguez Contreras.
On the screen, I have the Tribular Indictment that was filed in cause number ending in 7042. It alleges the offense of felon in possession of a firearm. State, are we proceeding as charged on this case?
Yes, Your Honor.
Mr. Rodriguez, do you understand the charge in this case?
Yes, Your Honor.
That's a third-degree felony, and it's punishable by confinement in the Texas Department of Criminal Justice, the Institutional Division, for any period between 2 and 10 years confinement. It also carries a possible fine of up to $10,000. Do you understand that range of punishment?
Yes, Your Honor.
Okay, let's move on to the cause number that ends in 7043. The indictment is on the screen. State, can you tell me how we're going to proceed on this case?
Yes, Your Honor. The state moves to waive and abandon the repeat offender enhancement allegation and proceed on the indictment. Further, the state intends to proceed on the lesser included offense of aggravated assault with a deadly weapon as a second-degree felony.
Okay, so a second-degree felony, Mr. Rodriguez, is punishable by confinement in the Texas Department of Criminal Justice, the Institutional Division, for any period from 2 to 20 years confinement. It also carries a possible fine of up to $10,000. Do you understand that range of punishment, Mr. Rodriguez?
Yes, Your Honor.
All right, both of these matters, your rights and duties, I'm going to explain to you the same thing. It applies for both cases. Okay, so when I explain something or I ask you something, it's for both cases. You have the right to a jury trial. You have the right to cross-examine all of the witnesses against you, and you have the right to remain silent. Those are your constitutional rights. Do you understand those rights?
Yes, Your Honor.
When you sign this document that I have on the screen, the court's admonishments, what you're telling me is you want to give up those rights. Is that what you intend to do?
Yes, Your Honor.
Is this your electronic signature? And this is for case number ending in 043 above the words Francisco Rodriguez. Is this your electronic signature?
Yes, Your Honor.
And is this your electronic signature? This is for cause number ending in 042 above the words Francisco Rodriguez. Is that your electronic signature?
Yes, Your Honor.
Are you a citizen of the United States?
No.
Okay, I'm going to ask you some questions, Mr. Rodriguez Contreras, and then I'm going to ask your attorney some questions first, and then I'm going to come back to you. So, Mr. De Los Santos, did you advise your client as to the possibility of deportation, exclusion from admission to the country, and denial of naturalization under federal law?
Yes, Your Honor.
And do you believe that your client understood your advice regarding those possible consequences?
I do. He did.
And is it your belief that he is entering into this plea understanding those consequences?
Yes.
Okay, Mr. Rodriguez, did your client advise you about the possibility of deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
And do you understand those consequences?
Yes, I do.
Okay, and knowing those consequences, Mr. Rodriguez, do you still want to go forward on this plea?
Yes.
Okay, I do find for purposes of the record that Mr. Rodriguez was admonished by his attorney regarding the possibility of deportation, exclusion from admission to the country, or denial of naturalization under federal law. And I do find that Mr. Rodriguez is entering into this plea knowing and understanding those consequences and wants to move forward. So now, Mr. Rodriguez, it's my turn. I also have to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Rodriguez, are you satisfied with the representation of your attorney?
Yes, Your Honor.
Mr. De Los Santos, does your client have a rational and factual understanding of the proceedings against him?
He does, Your Honor.
Has he been able to assist you in the preparation of any defenses?
Yes, he has.
And in your opinion, is he mentally competent to waive his rights and enter into the plea?
Yes, he is.
I will accept the waiver of rights, and I will make it part of the record. Mr. Rodriguez, here on the screen, I have the plea bargain agreement that you made in this case. This is cause number ending in 042. It calls for 2 years confinement in the Texas Department of Criminal Justice, the institutional division. There are no applications for probation, and this case will run concurrent with the aggravated assault with a deadly weapon. Is that your understanding of the agreement in this case?
Yes, Your Honor.
And on 043, same deal, 2 years confinement in the Texas Department of Criminal Justice, no applications, will run concurrent with felon in possession of a firearm. Is that your understanding in this case?
Yes, Your Honor.
Mr. De Los Santos, is that your understanding?
It is, Your Honor.
State, is that your understanding?
It is the state's understanding, Your Honor.
I'm going to start with the aggravated assault with a deadly weapon. Mr. Rodriguez, what is your plea? Is it guilty, not guilty, or no contest?
No contest.
What is your plea in the felon in possession of a firearm? Is it guilty, not guilty, or no contest?
No contest.
Are you entering a plea of no contest because you have talked about this matter with your attorney and you believe it's in your best interest to do so?
Yes, Your Honor.
Has anyone forced you to enter a plea
No, Your Honor.
or offered you anything in exchange for your plea?
No.
I will accept your plea of no contest. I do find the plea is voluntarily made, and I will ask the state to tender its proof.
In both cases, I have attached evidence to be offered through the Adobe Sign format. As well, I have forwarded evidence by way of email that was too large to include in the preferred Adobe Sign format. I forwarded that email to the court and included opposing counsel in that correspondence. All that said, the state now offers into evidence State's Exhibit 1 and all of its attachments in both causes before the court, pending any objections from opposing counsel.
No objection, Your Honor.
States one in both cases is admitted. Mr. De Los Santos, are you satisfied in both of these matters that the state complied with Article 3914?
I am, Your Honor.
I will sign the discovery acknowledgement and make it part of the record. Give me just a minute so I can read all of this. Travis, can you double check and make sure that he didn't get charged with anything in the vape pen? Or that anything pending?
Sure. Yes, Judge. One moment.
Before we go on the record, I just wanted to get an answer on that because it lists a lot more offenses than I guess what was filed.
Sure. Yes, Judge. Speaking from experience, when defendants are arrested and brought to magistration, it's typically a policy of the district attorney's office when they're charged by complaint with felonies, that misdemeanors that don't involve a complainant witness are not accepted and thereby rejected at the magistration process. Here, he was also booked with resisting arrest, possession of marijuana, and possession of a controlled substance, penalty group 2A, which being the vape oil, all of those being misdemeanor offenses and not enhanceable. So based on my experience, it's I believe that they were dismissed at the magistration level. That said, I've also cross-referenced my office's pending cases. I do not see anything pending for this defendant, nor do I anticipate any new charges coming, nor do I anticipate we would prosecute any new charges that would arise out of this same offense.
Okay, well, let's go back on the record. I do find the evidence is sufficient to substantiate your guilt. Mr. Rodriguez, in cause number ending in 7042, I find you guilty of the offense of felon in possession of a firearm. I will sentence you to 2 years confinement in the Texas Department of Criminal Justice, the Institutional Division. You do get credit for the time you have been in custody on this case. This case is a plea bargain case. I did follow your plea bargain agreement, so you do not have a right to appeal. And then in cause number 7043, I do find you guilty of the offense of aggravated assault with a deadly weapon. And I am going to sentence you to 2 years confinement in the Texas Department of Criminal Justice, the Institutional Division. There was no mention in the plea paperwork about an affirmative finding of deadly weapon, but by statute, I am required to make it since he is guilty of the offense. So I do make an affirmative finding that a deadly weapon was used in the commission of the crime. And I will sentence you to the 2 years confinement in the Texas Department of Criminal Justice Institutional Division. You do get credit for the time you have been in custody. These matters will run concurrent with one another. So 2021 CR 7042 will run concurrent with 7043, and the 7043 will run concurrent with 7042. This is also a plea bargain case. I did follow your plea bargain agreement, Mr. Rodriguez. You do not have a right to appeal. And based on the representations made by the state that there is no other cases pending and that none are expected to be prosecuted, if that were to change, Mr. De Los Santos, please notify Mr. Rodriguez.
Yes, Your Honor.
Okay, thank you. You're all excused.
Thank you very much, Your Honor. Have a blessed day.
You too. Take care.
Adios.
See you guys tomorrow. Thank you, Travis.
Adios.
All right.
Thanks again, Travis.